Yeah, okay. Okay, on behalf of Judge Freeman, this is Stephen Gockley. I'm going to call to order the pretrial processes work group meeting August 5th, 2022 for the Incarceration Prevention and Reduction Task Force. We don't quite have a quorum yet, but we're going to start with the first item on the agenda, discussing their performance measure ranking and the data elements. And that will start out with a report back from Dr. Andrew Peterson from the Administrative Office of the Courts. Dr. Peterson?
Thank you. Well, thank you to everyone that filled out the ranking. We got a couple last minute ones. Sorry, excuse me. And so now I think we have representation from at least one Superior Court judge, defense, prosecution, the pretrial supervision group, and some treatment providers. So I think there's pretty good representation now. I'll leave it up to you if you want to include more. I don't know, excuse me, if district court judges should be included in this or not. I'll leave that up to you. Otherwise, I think we have enough. Am I able to share my, doesn't look like, am I share my screen?
Let me give you that ability, Dr. Peterson, just one moment.
Thanks, Joe. And again, really, just call me Andrew, everyone.
Sure. I've just given you co-host ability, so that should give you share screen.
Great. Thank you very much. Yes, got it. Okay, so let me show you what we see here. Excuse me. Okay, so I went through and I got scores from everybody. You can see there are 3, 6, 9 people submitted rankings. And so then I just averaged them across and rounded. And so we've got this group of 13 or 14 elements that got a score of 1, and then another almost as many that ended up with a 2, and no groups got a 3. So that means 1 is those are elements we definitely want to report on, questions we definitely want answered and regularly reported, and we would go out of our way to make sure that that happens. 2s were groups that we would like reports on, but if the data doesn't currently exist, then we're okay missing it. We will make sure that data is created. If it already exists, great, we'll report on it. Otherwise, it's okay. So we've got this group here, which is great. It's a good number. Obviously, some very important ones. Who's committing new offenses, who's complying, new violent offenses. All released, all these. I'll send this to everyone through Jill, so that you can all take a look at this, and so you know what to expect. The next phase will be to go through this, and so it's figuring out now what data do we have available out there to answer these questions, right? And so it's the element necessary. So FTA data, jail booking data, jail release data, for example. Where does that come from? And then is it currently collected? And so if it's not currently collected and it's one of those questions has like a number 1 priority, we'll have to figure that out. Otherwise, I think we're ready to go forward. And then we just need to figure out then if there are things where it involves integration of multiple data sources. So say, for example, something relies on data that's held at the AOC and data that's held at Whatcom Sheriff's Office. That's the WSO in here. JS is just the data system that the AOC uses. If data comes from different places, how do we get those together to talk to each other so that we can report on those? But that's something I can try and figure out. So you guys don't have to worry about that too much, hopefully. And once I get this done, hopefully by next meeting, we can start getting these things together. So I think that's what it looks like right now. And I think, again, I really appreciate everybody who took the time to fill out the ranking and prioritization. That was really helpful.
Thank you, Andrew. Judge Freeman, I think, is back, so I'll turn this back to him in a second. I think we're gonna probably open this for questions or discussions perhaps. And so I'll just ask if anybody has any thoughts or questions they want to pose to Dr. Peterson.
And I recognize it's a lot of information at once, so I don't expect all questions to come in right now. And of course, always, feel free to call or email, as questions come up, and I'm happy to respond.
I had a couple questions if this is a good time.
Good time for me. Yeah, of course, Carol, please.
Thanks. And I realize I've missed at least one meeting, maybe two, and I may be thinking about this in ways that are not helpful, and I'm happy to just step aside with that. I wondered if it might be helpful for some part of this group to take some time and really think about what are the questions that we most want answered before we even look at the specific details of the data that can be collected. Because I wasn't I kept trying to look at this list and I did not actually rank them because I ended up with too many questions when I looked at the list. And also some questions about, so when we're collecting this data, does the data stay connected to specific individuals such that we can look at multiple levels of questions around the same data set, like not just demographics of who was detained versus who was released, but demographics of who was detained versus who was released at each level of risk assessed, like that kind of thing. So that was one question. Another thing that comes up for me every time we're looking at this is we look at, we're talking about who was detained versus who was released. And there's a category of people where bail was set and posted, which seems like a really different group of people than people who are intentionally PR'd with services or PR'd without services. And I'm wondering if there's a way to track outcomes for that group separately from people who are PR'd. And then that for me leads to this whole list of questions of how are we responding to community safety concerns through the court system, and what are the options that judicial officers have? Because what I'm still seeing in many superior court cases of domestic violence and sexual assault crimes is that really the only safety measure that is consistently used is setting bail. And then some people are posting bail and some people are not posting bail. So the distinction between who has court conditions that they're having to live with and who does not is entirely based on who has financial resources and who does not. And then people post. Anyway, so that raises a whole set of questions for me around pretrial monitoring options, which I think is also on our agenda today. So sorry, that was a long set of things, but this raised more questions for me than I answered when I started looking at it.
Okay, well, good. Thank you. I appreciate that. I think I understand what you're saying. There are some parts of that I'll leave, in terms of options, I'll leave for the judicial officers, I'll leave to people more in that side, and pretrial options and conditions I can leave more for, John or Alan or somebody that's more qualified there. Data wise, I can say that, yes, we can. First of all, this is an iterative process. So that we're at, this is the first phase of it, right? Where this is our first attempt. Nothing is set in stone. That's the beauty of this. And, we'll make a first run. And if there are things that we want broken down, like you said, across different levels, right? So you kind of have subcategories or what it is, we should be able to do that for the most part. I think I like to think of it kind of like each case is like a tree, and so you have all these branches that kind of go out. So if it's at the case is the thing that connects all of those together, right? So their case or that individual, and then you include their demographics, you include that case characteristics, you include their criminal history, you include the factors that go into bail setting or whatever it is. But they're all connected along that trunk, which is that case. I don't know if I hope that analogy made sense to people, but yeah. And so each way, while you're looking at each individual branch, you can also, because they're all connected, pull out the other branches that are connected there as well, if that makes sense. Again, I feel like I'm torturing this analogy, but it allows for that kind of multi-level, as you said, or as you described it, ability. And I think that makes sense, that you'd want to look at kind of those differences, not just who gets released, but what type of case it is coming in, or looking at the demographics of the individual, or whatever it is. And I think, I think that's certainly a possibility down the line. But my goal is to get kind of this first base iteration out, and then we can make adjustments from there. And I don't anticipate those adjustments taking long, because that information should all be in there, right? We should be able to do iterations quickly as we find out that we want or need more information. Is that?
Can you hear me?
Yes.
Yes.
Just here.
Okay, good. Hi, everybody. Well, Andrew, just the questions that Carol asked seem, the points that she was asking about whether they're retrievable, they seem like all of them good points for us to know. And are you confident that all that information can be teased out from the statistics as we're gathering them now?
Yeah, I believe so. I mean, I think if you have a case number or a cause number, kind of that basic key, right, that'll tie all these pieces of data together, through at least the AOC database, we'll have the demographics of the individual, we'll have the charges involved. I know John and Ellen collect more data kind of in pretrial supervision if that individual is on supervision. The sheriff's office will also collect information with the cause number there, so we should be able to pull all those pieces together and link all those different pieces, and so that based on that key of the case number or cause number, get that information that we want.
Okay. I know that I'm going to be especially interested in information about compliance with pretrial conditions and how compliance goes among the 3 tiers of pretrial services, and to the extent that there's a necessity for compliance. Well, yeah, to the extent that for bail people too, is what I'm trying to say, compliance with their aspect of, usually their restrictions are going to be pretty minimal, but still showing up or putting in an appearance through an attorney for hearings. I'm going to want to know all of that information by tier level or level of services, and it sounds like that's doable.
I think so. Yeah. I think what we'll also have to figure out at some point is kind of the period of reporting. Is this something that's what you want done quarterly, semi-annually, whatever it is. And I think some of that will depend on the complexity of pulling all these data sources together. So I know, I don't want to be calling the sheriff's office every week to get new data.
Sure.
I don't think they want that.
I doubt it.
Yeah, it
No,
doesn't bother me so much. I guess they would.
I would think a quarterly basis would be good, unless there's reason to, was it semi-annual, biannual? Doing it every 6 months seems, I'd be more comfortable with quarterly unless there's a reason to do otherwise.
Okay. Yeah, quarterly makes sense to me. That's also how I get my AOC updates. I could get them more often, but quarterly is already the regular schedule, so that works.
And you asked about other sources of information, Andrew, and we don't know who the second district court judge is going to be yet, but of course we know that Judge Anderson is there and going to remain the district court judge since she has no opposition. I think we should get her input as well. I think it's doubly important actually, since she's the only district court responder at this point. Judge Freeman, would you like to contact her? Would you like me? I'm happy to contact her if you prefer, but let's.
I have to reach out to her anyway on a different issue today, so I'm happy to reach out and invite her to.
Good,
meeting.
thank you.
Yeah.
Thank you.
Thank you both.
Does anybody else have any questions or comments on that item on our agenda?
Yes, I do. Andrew, I guess I have sort of two sets of questions. One is, if I understood your initial introduction, those factors that are scored 2, we will track if we already get that information, and we won't track it if we don't already collect it. That causes me some concern because some of these I consider pretty important, and maybe we should be tracking it. Maybe we should be collecting it, and we won't know that if we just let it go passively because we don't already collect it. So I'm troubled by that methodology. I don't know what to do with that.
Okay.
But there are a number of those things in there that I think are pretty important for us to know. And I'm thinking about number 17, the comparative demographics, and number 20, the success rate when judges adhere to the scoring versus when they depart from it. And so how will we ever expand our attention and our data gathering beyond that first tranche of factors?
Sure. So like I said, it's an iterative process. So we can always revisit this if we decide, if the group decides, because your voice is what matters here. This is, your constituency. So I think before we dig into that, though, let me go through and I'll talk to Lieutenant Erickson at the jail. I'll talk to John and Alan about the data they're collecting, and I'll think of if there are any other sources. I know the AOC data pretty well. I think if there are any other sources that may contribute to this, maybe the prosecutor's office keeps some of this or something, and try and put this together. And so I think before we try and override the rankings as they are, let's see what actually would be left out, because for example, number 20 is really just a combination of the adherence and the success rate, both of which are number 1s up here. Right, so they're already going to be captured. The elements that would create that already we guaranteed are going to be captured by the ranking up there. So I don't think that one we have to worry about, for example. And I think a number of these, are going to turn out to be, well, we already, we do have that data. So let's find out what will be left out, and that will be, hopefully a very short list. And then, at some point I can circulate again through Jill, maybe which of those factors would be left out, and after I go through this part, the data element availability, and I'll know more then.
Well, that's helpful to that concern, and I appreciate that. I look forward to seeing that. I guess my last question before I turn it over to Carol is you talked about the key into the vault being the case number. A lot of what we're going to be wanting to be tracking is sort of aggregate kinds of data, and so is the individualized case data going to be clumpable in an aggregate way, and if it is, how labor intensive is that? Because all of the system partners are really pressed for workload issues. We're finding that out. And so
Sure. Yeah, that's a good question. And I don't know workload wise how available or how prompt for example, the sheriff's office would be able to get me data. That's something I'll have to figure out. John and Alan have been great about sharing data when I've asked. And so fingers crossed, hopefully that can continue. But I think it's in terms of logistics of putting it all together and getting it aggregated, it's fairly easy. I mean, I have the software to do that, and it runs quickly. It can run quickly. Our AOC database has like 20 million cases, and it can pull up within a minute. Aggregate all these things. So I'm not worried about that issue in terms of being able to put everything together and report and aggregate. The case number being the key is really just connecting all those pieces, and making sure that you can kind of dig in and get those multi-level issues as Carol was mentioning, and you can figure out release status by demographics or whatever the issue is, and also connecting those different data sources together, right, along a common line, so that we know we're matching up person A with person A's case details or whatever it is, and using that as the key to connect those pieces. Does that make sense?
Yeah, I think it does.
Okay.
And so I'll pass the gavel back either to Judge Freeman or Judge Garrett, whoever wants to take on the facilitation of this.
Well, I'll defer to you, Judge Freeman. You're the judge.
You can go ahead, Judge Garrett. I think I think this is my first meeting back of the subcommittee for the last few months. So.
Okay, and that's fine. I think that finishes our discussion of the first item on our agenda. Carol, do you feel
Judge Garrett, Carol's had her hand up for a little bit.
Yes, oh, I see Carol, yeah.
Sorry, and thank you.
Oh.
I wanted to echo some of the concerns that Stephen is raising, and maybe just raise again the question of whether it would be helpful to take some time in some form to start to consider this from the other side. Like, what do we want to know rather than what data is available? And I'm particularly concerned that from the entire time that this group has been meeting, we've had a very clear priority of wanting to look at incarceration in Whatcom County with a racial justice lens. And to that end, the demographic information has to be a priority #1 issue. And I think it ended up as a priority #2 because we're looking at what data can we collect. We're not stopping to think about what really are the questions that we need to answer and consider and track. And so I'm just concerned that maybe there's a step that it might be helpful to take before we go too far with collecting data that might ultimately be incomplete for significant questions.
You're right, Carol. And actually, that was one of the questions I wanted to ask. It doesn't seem like any of the categories in any of the elements of category 1 have race in them. There is the category 2 information about race, but I do think we want to be, thank you for sharing that, Andrew. We do want to be looking at race. Where's the racial one in paragraph 2? Yeah, number 17. And is that, I think that's the only one. I think we clearly do want to know racial information about who goes on pretrial supervision and who doesn't. But I think, I don't know, Andrew, perhaps you can answer that.
Sure. I'm not concerned about, so I'm not concerned about it because I'm very confident that we have it. You know, the demographic reporting is something that AOC does quite a bit. And so it's, you know, that's attached to each defendant that comes, you know, has a case filed. And so, yeah, I'm not worried about, you know, large missing section, you know, demographic information, race, whether it be race, ethnicity, gender, age, any of those things. I feel confident that the AOC, at least the AOC, will have. I'm about 95% sure that John also captures it for pretrial supervision, and I don't remember. I think the jail may also. So, and Lieutenant Erickson I saw was on here, so he can speak to that better. But you know, and then we can also look at if there's disagreement between the three groups. You know, what, because race ethnicity is such a, you know, it's a construct, so it's not going to be perfect ever. And we have narrow categories that people may not fit neatly into or fit themselves neatly into. So that can be an issue that can be kind of a unique opportunity too, when we have, you know, different data source, you know, different groups collecting kind of the same general information, to look at that and get maybe a better picture or fuller picture of what that looks like.
Okay.
I'm just going to say what I think Stephen and Deborah have already said, but to me, the demographics are probably one of the key elements that I would like to see. And part of that is being a practitioner. I think I've already said over the last 6 months or so that I am concerned with what this data is really going to provide us when we've had the COVID outbreak, and then also what's going on with, as far as jail booking restrictions. We have an entirely different kind of class of individuals that are largely being detained now that we didn't have 2 years ago when this all started. And so I'm not sure what those numbers are going to tell us about pretrial release and length of time on pretrial, whereas I think the demographic numbers are going to give us an actual insight as to how this is being applied across the board, however else kind of the pretrial numbers stack up. And so that's why I see it as a very important factor that we should be looking at.
And to the second part of Carol's question, actually, I think it was the first part, that we should be thinking also about what are we trying to find out? Not so much what can we find out, but what do we want to find out? Carol, I think that's a good question. And I guess I don't know what else we're trying to find out. So to make a suggestion right now about other information, this seems like good information to me, and I don't know. Could you expand a little more on what the other information would be that we'd be looking for? Or are you saying that that's those are the unknown unknowns?
I just wonder if it's a question worth considering just from the perspective of the question. Like, should we take some time and think about, if we want to see how well this system is working, what is it that we really want to know? What would be the indicators of that? And maybe that's absolutely reflected in our instincts about what data is most significant, except the fact that some of, you know, that the demographic data, which does seem key, didn't score as high as priority, which just makes me think like, okay, maybe there's a different angle that it would be worth some time to just ask the question. I don't have an answer to it.
I can say that, you know, these questions that or the information that I had you all prioritize before came from the work that came from a couple of sources. One, it started with the National Institute of Corrections, or Corrections Institute, which is part of the U.S. Department of Justice, put together a thing called Measuring What Matters in pretrial. And so they had experts from around the country. Some were pretrial supervisors, some were judges, some were attorneys, that kind of came up with these, basic elements that they felt needed to be measured. And then that list was taken and slightly adapted by some outside research groups. And it's the list that's being used in Thurston and Pierce counties as they do their pretrial reform. So that's where this came from. So it wasn't just, and I don't think you're implying this, but just to say, it wasn't just kind of something that I threw together or that was, kind of pulled from random or, one brainstorming session or something like that. So I think it does have some basis. Again, it's not, it's not the ultimate list. It's not by any means a final list. And if there is something that you feel is important to be measured, I'm happy to see if we can include more and answer some more questions on there. And I think, it's I go back to it, it's an iterative process. So let's see what, after we come up with the figuring out the data sources and what's available and what will be reported on, maybe that's what is needed to figure out what is missing, right? What could be added after that. Sometimes it's one of those things that's where it's easier to edit than it is to come up from new, create from new. For all the writers out there who are staring at blank pages, it's easier to edit your work than it is to try and type a new page. So, maybe once we see something on paper, it'll be easier to say, oh, but what about X or what about Y? And we can go from there.
I tend to agree just because of what I already said, which is, I think it's important to look at the information that we want to know as opposed to the information that's available. But I can't think of other information that we want to know that's not reflected there. I suspect when we get that information, that may lead us to other questions, but that makes sense to me, Andrew. What do you think, Carol?
The only thing off the top of my head that I would add would maybe that category, separating out people who have posted bail from people who are PR'd, especially if there's significant bail, like that makes a difference as well. I'd like to know what those outcomes are. I'm sure there's other questions, but that's.
And of course, people who post bail, they're not subject to a lot of conditions, but they're subject to some. No new charges is certainly one of them. And that's an important one for all of us. So we'd want to know that for sure. Obviously, there's not going to be compliance with pretrial services conditions, but they still have to stay out of trouble and show up for their trials. And we want to know that. Yeah. But Andrew, it sounds like we can do that. We can get that information, right?
I think so. Yeah, I believe so. Also, I don't know if this is the right time, but I'm involved with these groups in Thurston and Pierce. They're doing their work, and the group in Thurston, in particular, the public defender there has partnered with one of the research groups, and because bail information is oftentimes a mystery, or at least, if not a mystery, it's you don't get everything that you want, right? You might just get one number, and there's really more nuance involved there. And the defense attorney, again, partnered with this researcher, outside researcher, came up with a data collection instrument, just again, a spreadsheet, where they capture the case number or cause number. They capture the date that it happened, whether it was whether it's a violent offense or non-violent offense. They capture, and I think this is the key, they capture what the defense attorney is asking for bail-wise, what the prosecutor asks for, and what the judge ultimately issues. And so having those three elements, and then they also capture the factors upon which the judge bases the ruling. So whether it was FTA or violence or interference of the administration of justice, and then it adds that nuance and lets you see what really went into that bail ruling and how those those three parties differ in their approaches. And the public defender there has made that has offered that instrument to anybody who wants to use it. Again, it'd have to be manually collected by somebody. But he said he's willing to share that if anyone's interested in doing so.
Okay. I think that finishes our discussion of item 1, but I just want to say that I think Carol's question is a very good question that we should all have in mind on an ongoing basis as we get this information and go through it. We want to keep in mind, what do we want to know? Not just what do we know, but what do we want to know? And so let's, Carol, with your help, let's revisit that question again as we start to get data, because will continue to be relevant, I think.
Judge Garrett, one last question. Andrew, as I understand it, from what you said, we have a couple more inquiries to make about sources and availability of data, but then you'd be ready to start. Am I right there? And how soon would you expect that you could give us the first quarterly report?
Well, sorry, go ahead.
Well, what I'm thinking is that Dave Freeman will talk to Judge Anderson and get her input on a pretty short-term basis. Like, she should be, I mean, it's not that lengthy a process. So if he can get her to do that within the next couple days, that I think is the last piece of information I see as necessary before Andrew begins to work his magic.
Yeah.
Dave Freeman, do you agree?
Yeah, that should be no problem.
It's not that I was worried about. It's the time frame for pulling the rabbit out of the hat. You know, how long are you using the last 3 months of data then and running them through these factors? So I guess I'm wondering, how long does it take you to crank out a quarterly report?
Good question. One, I want to clarify, this is not magic. Very, very not magic. It may seem like a mystery, but I promise you that there's nothing secretive or no black box here. I want to be very transparent how this is all done.
It was a poor choice of words on
No,
my
I know. I was, again, just kind of playing with the analogy there, but you know, I don't know. I'd like to think a month, but you know, let's see how how complicated it is to pull some of these data elements together. You know, if there are different sources for a lot of these, it may take longer, and seeing how well kind of the data plays together and connects, because that can get complicated. If everything goes smoothly, I'd like to think a month we could start having some reports. And then, you know, then once I have the information, we can start playing with what it looks like and get it to an easily readable and digestible format. But yeah, let's optimistically say a month, assuming things go well.
Part of the reason I ask is because Judge Freeman, Judge Garrett, and I have recruited a couple of community members of color to sit with us and look at what those reports look like, especially from a racial disparity point of view. So I'm trying to get a sense of when we might want to start looping them back in. My sense is that they've been waiting for some time for us to get up to speed. That they've been willing and available. So I guess we won't know that exactly. If I could interject before we go to Dave, the other question I have on this data is, and I know that this doesn't come from the Superior Court perspective, but a lot of our reduction of incarceration has come from booking restrictions. So there's a whole slew of people who get citations and never get to the point of a PSA scoring. And we as a group or the Superior Court judicial officers won't have any ultimate control over that, but is there any, are citations entered into AOC data? Would there be any basis for us to say these restrictions are not serving one of the purposes we consider important, for instance, no new violent crimes, say? Is there a way for us to track that group of people? Is that even something that we care about at this point?
You mean the people that were cited and released and then appeared for court on their own? Is that what you're talking about?
Well, I'm not sure what I'm talking about, to be honest. I just know from a recent report Caleb gave us that there's a not insubstantial number of people who we've diverted. I mean, they have cases, I guess.
But we're never booked into jail.
Yeah. I think Judge Friedman is going to help me here.
Yeah, what I would say to that is that due to I would say the booking restrictions and some of the policies, what we are seeing as far as who is actually, and my understanding is the PSA is only applied if there's a first appearance in custody. So those having first appearances in custody are a different variety of offenders than what we would have seen in the past. As Caleb has indicated, and I think Wendy has indicated at one of our meetings, we have a higher risk population in the jail right now, likely higher rates of violent offenses. And it just seems to me that a lot of the people that we normally would have been targeting with the PSA and for release are the ones that are being diverted from being booked originally. And so I don't know how we measure that. It's not, yeah, but it is a different demographic that we're seeing at the 3 o'clock in custody calendars in the afternoons. And Maya might have a little bit of insight on that as well, I would imagine, but.
So currently, the people who are in the jail are charged with much more serious crimes than, I mean, as a group, than was true 2 years ago or before COVID. Right?
I think that's true.
Yeah.
And can I ask, are the booking restrictions still in place? Okay. So yeah, obviously that would limit our ability to, let's say, compare this group to a past group or even a future group, you know, as this continues. We can kind of go backwards in time and look at bookings that happened, you know, prior to the restrictions, possibly. And AOC data goes back there as well, so we can, you know, match those up. So we can talk about that. However, of course, pretrial supervision didn't exist then either. So, you know, that's gonna look a little different. So not all metrics that we're looking at will be applicable to kind of the historical group. But, you know, it's just, I think it would just have to be one of those kind of asterisks on this time period that, you know, we know this is going to look different because of outside circumstances.
Is it possible to overlay the jails data? Because I know, and Caleb, I'm sure can speak to this a lot better than I can, but I know from what I see on reports from Wendy Jones that there has been significant tracking as far as the violent offenders, or it seems like there's been significant tracking over the last couple of years through the jail of what their population is. So is it possible to overlay that with our PSA data and who's being seen at the first appearances versus being either booked and released or not booked at all?
I think that should be possible. Yeah, like I said, you know, we just need that kind of common key to, you know, a shared key that we can use, whether it's cause number or if we have to go to name and date of birth or something like that, we can find a way to match those up.
Is there any possibility of using the PSA more broadly, not only on people with cases where someone is booked into jail, but for other first appearances, even just to collect that data?
That's what I'm wondering too. Yeah.
I mean, I suppose it would depend on what the goal would be there. If it's, you know, I don't want to use it outside its intended purposes. Explain it to a group that it's not intended to be used with. So we have to go back to what the Arnold Foundation and APPR says about PSA use. But I mean, I think in theory it's all static data, right? You don't have to do interviews with the individuals, and so it should you should be able to pull that information. It's mostly just their criminal history.
So Dr. Peterson, is it possible to use the charging as the common denominator versus those booked into the jail versus those summoned in, and then run those separately?
Yes, exactly. And
I thought we should be able to capture that data out of Odyssey.
yeah, exactly. Right. So yeah,
And that will also take into account people who weren't even taken to the jail. They were decided in the field and released, because that's a population we're missing otherwise.
exactly. Yeah. So what
So if whoever's charged, we evaluate, cited and released, booked and released versus, first appearance. And then what happened from that. So I would think that that information would be available using, the codes for notice and summons and charging in Superior Court.
Yeah. So when I match those up, when I take say booking data and the AOC charge filing data and match those up, right, there are going to be some that don't match, right? They don't have a common link. And if they're in the jail data or the booking data, but not in the charge data, the assumption would be that case was dismissed. They never.
Or we went to district court or something else too.
Exactly. It went down to a different place.
If we like, I think we looked at Superior Court charging as the common thing, regardless of what happened with them, with the booking.
Right. Yeah. And vice versa. Right. So if they're in the charging data, the Superior Court charging data, but not in the jail booking data, then, the assumption I think would be that they were never booked into jail. They
Exactly.
just cited and end up there.
Exactly. Because
So yeah,
I know Caleb would not get the information if they were just cited in the field. That's a big population we're going to be missing otherwise. So the other question I had is, we've had people on pretrial for the last couple of years, probably about 200 over. Would you say, John, about 200 at place time?
Yes.
Do we have enough information on that to know what our population on pretrial looks like so far? And what are the barriers to those people getting to court or committing new offenses or anything else? It would seem like we have, we've got it's not a huge pool, but we have some information there that could be helpful to us.
Yeah, and I think so. You could definitely track them. I know John keeps a lot of that data, and whether they've had new offenses or FTAs. Also, it would be available through the AOC data to know, their kind of outcomes so far and how many people have not been successful.
Is there particular additional information you need from us at this time to assist with that?
I mean, not that I can think of. I'll have to talk to John to see what he has, because if he's already
Okay.
tracking it, no need for me to recalculate, right? Reinvent the wheel there. But
And one of the reasons I ask is obviously as we look at growing this program, what are the needs this program has? What's the reasons people aren't being successful? We're going to throw money at it and put people on EHM if that's not what the issue is. Is it
Sure.
bus passes? Is it, housing? What's the issue? So,
yeah, reminders or whatever it is, right?
Yeah.
No, that's a great point. The reason may be a little harder to capture. That might be something, the AOC wouldn't necessarily capture why a person failed or didn't show up.
Right.
Just
the pretrial might be able to get that information.
exactly. Yeah. So
Right.
yeah. So let me talk to John and Alan a little bit more and see what they have, and let's see what we can do that way. And I think that speaks to Carol's point about other things that you might want to be looking at that weren't necessarily included in that original list.
Okay. Next item on our agenda is about electronic home monitoring. And I'll be real interested to hear people's views on that. When we initially established the pretrial services unit, we didn't include electronic home monitoring as one of the services. And that frankly was because we were we had limited funding and we didn't have funding for electronic home monitoring. Establishing the pretrial services unit and getting that going was all we could manage. And we were pleased to get the authorization for that from the county council. Times have changed now, and it's time for us to reconsider whether electronic home monitoring is something we would want to see as part of pretrial services. And I'll open that for discussion. Perhaps we want to hear first from John Kraus and Dave Freeman and Dave Reynolds on their views about that. And I'm sure Maya will want some input as well. John Kraus, what are you thinking?
I'm thinking it's doable. We can, like you said, we need the resources. We need a vendor to provide the EHM. And I don't know what the liability is with us actually installing the EHM and handling it all, or the vendor does. And we just monitor the reports that come in from compliance, non-compliance, those kind of things.
Excuse me for just a second, John. We'll come back to you, but I'm looking at the time and realizing that Dave Freeman, you need to go on the bench at 1:30, don't you? So maybe we'll ask for your input first so we can release you before you're required in court.
So this is something that I have quite a bit of experience in the municipal courts and using pretrial monitoring there. I do see it as an effective tool if it's targeted, and it really is a lesser restrictive alternative to custody. So I think sometimes it's probably overly used in certain jurisdictions. Whereas I think if this truly was a incarceration reduction tool, then I can see it being highly effective. When it comes to the vendors, most of the municipalities were using, friendship diversion services. I've had experience with them doing both the installation and the monitoring. I've seen a few hiccups with that in Superior Court when we've tried to use it, but we don't really have a contract set up with a vendor. Those are for post-conviction monitoring. And so I have seen a few issues come up. I've seen less of that when there's a contract in place and you have a kind of a process in place for how it's going to operate. My other question would be either maybe towards Caleb, whether it would make more sense that it would be part of jail alternatives and be in-house versus a private vendor. I don't really know the answer to that, but.
Well, if you want my opinion, I think that jail alternatives could offer a solution in this regard. It's already something that is done through district court probation. And so I believe that it's a possibility, just broad brushstroke, throwing that out there, I believe would be a possibility.
It seems to me that this could be offered in place of incarceration, certainly, but also could be offered if someone violates their pretrial conditions. If the circumstances aren't serious enough to warrant incarcerating them pretrial at that point, but still they've violated conditions and some sort of consequence has to happen. Certainly, this is one of the alternatives that, in my view, should be available. Whether it's done in-house or through a vendor, I favor in-house if possible because there's more control and probably some cost savings. But that's secondary. Anyway, that's I see that as a pretrial condition and also a sort of second-tier pretrial condition for somebody who hasn't complied with their first level of pretrial conditions, but isn't appropriate for jail.
I don't disagree with that. The one thing else I was going to add is something that I'm sure Carol can speak to as well, is there are some very limited circumstances where it can be used as a tool for the protection of alleged victims as well. And that's done through GPS monitoring. So rather than have a house arrest style order, you have an exclusionary order where they're not to be in certain locations. And I have seen that work occasionally. I don't think it's used too often, but it certainly is a resource.
Okay, and Maya, we've got some input there. Yes, Maya. Oh, you're muted.
Sorry, thanks. I do have to leave at 1:30. So I have a couple thoughts. One on the exclusionary thing. I think you have to be very careful if you're assuring, like, because unless you've got like true immediate response from law enforcement, you're creating a really dangerous situation for the people you're supposedly protecting. And I think that needs to be really carefully considered. But also, and just, I just envision there being, we don't have a lot of pretrial release condition reviews in Superior Court. I mean, Judge Freeman, tell me if you disagree with me, but I do not. That's not something that is like a bulk of a calendar. They are, I mean, how many in a given week do you even see? I don't think there's that many. So I think we would just change the name. There's going to be a lot of pretrial compliance review calendar action. I think it just creates a whole nother thing. Like, that's just going to be a lot of work, more work than we do now, which isn't necessarily bad thing if we're getting people out of jail, but I want to be sure we really are getting people out of jail that wouldn't already be out, but not on this program, and that we're not just putting people on the program who would have probably gotten out on bail. And then we're creating review calendars that are likely to be voluminous is what I kind of see.
Well, initially, when we started pretrial services, we had established a system where if the person's violation is minor, they don't show up for an appointment with pretrial services, for example, then that's reviewed informally by a commissioner. And if there's not a substantial penalty, then no judicial action is taken. If some other penalty is being considered, then the matter is put on a pretrial review calendar. So the purpose was to keep the pretrial review calendar limited to more serious violations for just that reason. I realize we've done that only to a limited degree, but I think to the extent it's been done, it's worked. I don't know, Judge Freeman, what do you think?
I agree with everything that Maya said. I think, like I said, I think right now, especially with the jail situation the way it is, it would really have to be an alternative to custody. I do see, Judge Garrett, what you indicated as far as like a second tier, if there was a violation, maybe that would give us one more resource, because I'll admit, and Maya knows this, that part of the reason why we don't have those calendars for violations is that there's just such a restriction in the jail that the odds of us pulling people in right now are probably a lot less than they were a couple of years ago. And so maybe what you said, Judge Garrett, is this being a second tier of another tool that we would have to try to gain compliance with the pretrial orders, that it might be a good idea. But yeah, ultimately, I don't know what our alternative would be if they violate. And it could create some big calendars if we overuse it.
Okay. So are you saying that you would question whether we need to offer pretrial electronic home monitoring at all?
No, I think it's a very useful tool. I just think we would, in the current situation with the jail, I think we would just have to be cautious with our use of it, so that we didn't create a situation where we're having mass review calendars and violation calendars. I think it
Yeah,
should be
like
an alternative.
because once you use that second tier, if the use of pretrial monitoring results in like a lot more of violations because of the nature of that, then what do you do next? You have to put them in jail. So you've just created a situation where you're giving people an obligation that like, they mess up, they do this, but like in order to be effective, you have to ratchet it up, and then you're back to putting them in jail.
Well, that's a conundrum, but I'm not sure that it's hard enough. I mean, I don't know. I'm not on the bench currently, so I'm not seeing this, but to say we can't do pretrial home monitoring.
I'd want to, how much time is spent in jurisdictions that are using it? Because I'm just not familiar. How much time is spent coming back to court to say, or I guess, can they modify their schedules with the provider without any judicial input? Like, how much of this has to be how much oversight from the judge is there? Or is there a lot of autonomy in the monitoring part where they can say, oh, okay, you got a new job, no problem. Oh, your kid is over here, you need to go there. Great, you can do it. Or is there a judge having to have input on that?
I always found it to operate fairly smoothly in the municipal courts. One, usually, at least with friendship diversion services, it was fairly flexible as long as there was, as long as the individual came to the provider ahead of time, it wasn't an issue. I didn't see a ton of review cases, and maybe Carol sees more in Ferndale, but in Bellingham Municipal Court in particular, I didn't see a ton of reviews. So again, I really am an advocate for the use of it. I just think in the current situation, we just have to be cautious about the scope of our use of it. So.
That makes sense. That makes sense, but I do think it's something that we should be considering for those cases in which we'd be strongly considering incarceration if we didn't have EHM. I think we want to be conservative in our use of EHM anyway, because it's expensive.
Sorry, I gotta go.
Yeah, okay. Thanks, Dave. I'll talk to you later.
I know that there's no representative here from our prosecuting attorney's office, but I know that we have struggled trying to get them to accept friendship diversion, and like they may have, I can't speak to their concerns because we kind of disagree with them about it, but they may have issues.
Is their concern friendship, specifically that vendor, as opposed to the use of electronic monitoring?
Right, that vendor. And I understand you're saying in-house would be preferred, but I just wanted to say that.
Okay.
Do we have information about the process for geographic violations for the in-house electronic monitoring? One of the plus sides for friendship is that they do have the capacity. We end up seeing it used probably as much as a home detention alternative to incarceration, but as an enforcement tool around no contact orders in some domestic violence cases. And they do have the ability to do 24/7 notification of law enforcement for violations or for tampering of the GPS device, which I think both of those features would be really critical for any situation involving community safety concerns about somebody's location. Because if you're putting a bracelet on somebody and communicating that, okay, this person is restrained, and they cut the bracelet off, and the process is there's notification on the next business day to a probation services, and there's a court hearing scheduled, as Maya said, we'd be increasing risk instead of decreasing it. So I don't know what the capacity with the in-house options would be for that immediate law enforcement dispatch.
I don't either. I don't think we're not going to make a decision on this today. I think the best we can do is begin the discussion. I think we've done that. Does anyone, I would table this question for our next meeting. Does anybody have anything they'd like to say on that? Yes, Caleb.
Sorry, yeah. So I'm intimately familiar with the process of the internal, house process, because I was involved in setting it up through district court. And it is very much like Carol's describing. We're talking about a system where we get notification that a violation has occurred, and we notify the probation folks the next day, and then they are essentially called in for a court hearing. There is no immediate notification of law enforcement. There is no law enforcement response. And there's two reasons for that. Number one, if you provide the option, you have to do it. You can't just simply say, well, we provided a notification to law enforcement, but they couldn't go. And we all know that our law enforcement isn't necessarily available to respond to immediate notification on incidents like this. We don't have enough law enforcement in our community for that response. And so it puts liability on law enforcement, but there's no recourse for them to make that happen. And so the direction of travel we chose back when we first set this up was we get a violation, let the court know, the court or probation sends a summons, they go to court hearing as soon as the same day or the next day, but it is not immediate.
Okay, that's important to know. Because
And I'm sorry to interrupt, but one of the distinctions you have is if you've got a municipal organization that is in control of their own law enforcement. So, the city of Bellingham, for example, they're in control of their own law enforcement. They can say, you know what, we're going to respond to these calls. There isn't that availability throughout the community.
There's also that when we're seeing the GPS monitoring used specifically to enforce a no contact order, then a violation of that would be a criminal offense rather than just a violation of the court detention order. So I think that affects the law enforcement priorities as well.
And GPS technology is, it's kind of interesting. They don't have the ability to pinpoint somebody's location accurately to within 250 feet. So if you live in the same apartment building as your victim, there's no way on earth that you're going to be able to tell whether you're violating the no contact order. And so we found that different technology, even the older RF technology, works better in terms of pinpointing people's exact location within a range. But none of it is perfect.
Okay, to be continued. I'm also going to just, for the good of the order, continue the violent crimes definition discussion until we have our prosecutor and our public defender here to participate. So we'll put that onto our next meeting's agenda also. And I believe that finishes the items for discussion today. Does anyone have anything else they'd like to raise? Our next meeting is going to be in the beginning of October, and I'm thinking that with luck, we may have gotten a preliminary report from you, Andrew, before then. Do you think?
I think that's the hope and the goal. But this is the thing where I'll go into my cave and work on it. I'll keep in contact with you and let you know how it's progressing and we'll give you a sense, especially because, as Stephen mentioned, you guys want to possibly bring some outside people in, but only if we have information to share. So and make sure you guys you all are aware with enough notice of how things are progressing.
That seems good. Good. Well, we'll wish you luck in applying your analysis. I won't say working your magic, but applying your analysis in transparent ways that we can understand. And that's what we're looking forward to doing. Do we have other items for discussion right now?
I would like to say, if I may, the information that we have stored in the jail, I can get access to. I can make it available. You've got a willing partner in this, rather than there's no animosity, hostility, dragging feet, anything like that. We've got a pretty substantial COVID outbreak I'm trying to manage in addition to a couple of people who are acting out. So I apologize for being late to the meeting here. But the information, all I need to know is, what would you like to know? How would you like me to couch it? And, Dr. Peterson and I have worked together before on getting information, and I can continue to do that. So.
Good. Well, that's really good to hear, Caleb. Thank you for clarifying that and making that extra clear. All right. Thank you all for being here. Our next meeting, Jill, you can help me with this, but I believe it's October. It's the first Friday in October. And I just don't have my calendar in front of me.
Yes, October 7th.
October 7th. Yikes. seems like a long ways away now, but if it's anything like this date, it roared right up. So I hope you all have a good couple of months, August and September. What could possibly go wrong? I hope you all have a good August and September, and we'll see you all on October 7th. Okay, and that finishes our meeting. Thanks, everybody.